DACA and adjustment of status. In this video, I'll talk about DACA and adjustment of status. My name is Bijoux Ngwanda. I'm an immigration lawyer based here in DC. I do work with individuals across the country and around the world because we're dealing with complex US immigration laws. If you're new to my channel, please go ahead and subscribe. If you're not new, welcome back. Thank you for subscribing and thank you for watching. And please don't forget to hit the notification bell so you don't miss anything. If you enjoy the content, you're welcome to share, like, and don't forget to comment below us. So please don't forget to join us on our private Facebook group where we answer questions live at least twice a month. Let's get right into the subject, DACA and adjustment of status. We are going to divide it in two types, employment-based and a family-based type of petition. I-130 petition approved and I-140 petition approved. So can I adjust status? The question is, yes, you can, provided that you meet all other adjustment of status requirements. Let's start with employment-based. With employment-based, what are the requirements? Okay, enter with inspection. If you enter with inspection, and that's depending on what type of visa, because certain visa, as a matter of law, you just cannot adjust status. You have to just go through consular processing. We're focusing on the visa that is really eligible for adjustment of status in terms of if you meet other requirements later in the process. B1, B2, for example. You enter with a B1, B2 visa and you maintain lawful status and you meet any other admissibility requirement, then you'll be able to adjust status. But if you fail to maintain lawful status for more than 6 months, you cannot adjust status. Even though you are a DACA recipient, you have to get outside of the US. You have to use advance parole, get outside of the US, and go through consular processing, basically getting your immigrant visa from outside of this country. So the takeaway for employment base is that you have to maintain lawful presence. But if you fail to maintain lawful presence, it has to be for less than 6 months. That can be forgiven in terms of employment-based application is concerned and adjustment of status tied to it. Okay? So, family-based petitions, depending on who you're marrying. If you marry a US citizen and you enter with inspection, you can adjust status because we know that immediate relative, especially US citizen, you are going to be automatically forgiven for your unlawful presence. Okay, you can adjust status. If you marry a lawful permanent resident, you have to go through consular processing. Basically, you have to get outside of the US through advance parole and go through consular processing and get your immigrant visa from outside of the US. And that applies only if the only problem you're dealing with in terms of inadmissibility issues are unlawful presence. But if you're dealing with something else besides unlawful presence, you have to get a waiver approved. And we already know that with waiver, you have to be actually qualified in terms of you have to have a qualifying relative and you have to meet statutory requirements for waivers and apply for it and hope it gets granted because waivers are discretionary measures. Okay, so this is it when it comes to employment-based and family-based petitions for DACA recipients. I hope I've answered that question. Just to recap, DACA recipients can adjust status provided that they meet all requirements for adjusting status. Adjustment of status, the process by which you apply for a green card without you having to leave the United States. If you're applying through employment base, again, you have to meet the requirement. The only thing that will render you inadmissible is if you fail to maintain lawful presence for more than 6 months. Okay, that we're just talking about failing to maintain lawful status, right? So, but if you have other inadmissibility issues, my friend, you have to seek counsel and seek for waiver and be actually eligible for one. When it comes to family base, are you marrying a U.S. citizen or lawful permanent resident? Okay, if it's a U.S. citizen, yes, you can adjust status. If it's a lawful permanent resident, you have to go through consular processing. Again, advance parole, you can leave and go get your visa from outside. Okay, so that's how, or a waiver of unlawful presence, provisional waiver of unlawful presence, I-601A, get it approved first, get advance parole, leave the country, and go through consular processing. Okay, that's it for adjustment of status and DACA recipient. If you have questions or any other inadmissibility issues, please do not hesitate to contact me if you do not have any lawyer, right? You can call my office to 2751-2180, or you can just email bijoux.ngwandaesq@gmail.com, or you can click the consultation link in the description box, okay? So that you can consult and schedule your own consultation on your own time. Consultation fees applies as usual, okay? That's it for DACA recipient and adjustment of status, because we've talked about a lot about TPS and adjustment of status. I just wanted to answer this question for DACA recipient and adjustment of status. Until next time, bye-bye.